Good day. Welcome again to the Basic Philippine Law and Jurisprudence channel. This is again a continuation of the lectures on persons and family relations law. So our topic for today is support. Okay, as you all know, support is one of the consequence or result of filiation. So filiation, once it is established, gives right to certain rights and privileges. Among them is support. Now, what consists of support? Okay, support consists of the following. Okay, everything which is indispensable for sustenance, clothing, medical attendance, shelter, education, and transportation. Everything that you need to survive, that is support. Okay, in keeping with the financial capacity of the family. So support is relative, depends on two factors. It depends on the financial capacity of the giver and the ways or means of life of the receiver, the life to which the receiver is accustomed to. Education is also part of support. So what does education consist? It includes his schooling, training for some profession, trade or vocation, even beyond the age of majority. So it doesn't really matter if the person who is entitled to be supported has already reached the legal age. If he's still, for example, in college, pursuing his college education, then he is still entitled to support. Transportation shall include expenses in going to and from school or to and from the place of work. Okay, so uh, who are the persons who are entitled to support and who are the persons whom you are obliged to give support? Okay. Article 195 provides that the following are obliged to support each other to the whole extent set forth in the preceding article. So the spouses are obliged to support one another. Legitimate ascendants and descendants in the direct line. Okay, so your grandparents, ascendants, great grandparents, great great grandparents, regardless of degree. Okay, descendants, the grandchildren, great grandchildren, great great grandchildren, again, regardless of degree. So as long as you are related to each other in the direct line, whether in the ascending line or in the descending line, you are obliged to support one another. Okay, parents and their legitimate children, and the legitimate and illegitimate children of the latter. Okay, so with respect to their legitimate children, the parents are obliged to give support to them as well as the legitimate and illegitimate children of their legitimate children. So their grandchildren, whether legitimate or illegitimate. Parents and their illegitimate children, and the legitimate and illegitimate children of the latter. So, parents and their illegitimate children, as well as the grandchildren, whether legitimate or illegitimate. Legitimate brothers and sisters, whether of the full or half blood. So it doesn't really matter if the relationship is full or half. As long as they're related by blood, okay, you are obliged to support your legitimate brothers and sisters. Okay, the key word here is legitimate. You must be legitimately related. Okay, it doesn't matter if you are full or half blood. Okay, how about illegitimate siblings? Are they entitled to be supported? The following article, Article 196, answers that question. Brothers and sisters not legitimately related, whether of the full or half blood, are likewise bound to support each other to the full extent set forth in Article 194, except only when the need for support of the brother or sister being of age is due to a cause imputable to the claimant's fault or negligence. So, if you are illegitimately related, meaning you have an illegitimate sibling, you are also obliged to support your illegitimate sibling, except that there is an colatilia. If the illegitimate sibling is already of age, and the reason why he needs support is due to a cause imputable to his fault or to his negligence. Like, for example, he has all the capability to work. Okay, he has the qualifications to land, for example, a decent work. However, he refused because he was so lazy. Okay, and he just wants to be a bum for life. So in that case, if the relationship is not legitimate, meaning it is illegitimate, you're not legitimately related, okay, you're not obliged to provide support to that sibling. Okay? Okay. Article 197 provides that for the support of legitimate ascendants, descendants, legitimate or illegitimate, and brothers and sisters, whether legitimately or illegitimately related, only the separate property of the person obliged to give support shall be answerable, provided that in case the obligor has no separate property, the absolute community or the conjugal partnership, if financially capable, shall advance the support which shall be deducted from the share of the spouse. Okay. Now, what if there is a legal separation proceeding or annulment of marriage proceeding? From where should support come from? Okay. Article 198 provides that it shall come from the properties of the absolute community or the conjugal partnership. Now, after there is already a judgment which has become final, granting the petition, the obligation of mutual support between the spouses will cease. Okay, however, in case of legal separation, the court may order that the guilty spouse shall give support to the innocent spouse, specifying the terms of such order. Okay. So, um, in case there are two or more persons who are in need for support or who are obliged to give support, who shall provide support first? Okay. So, Article 199 provides as follows. Whenever two or more persons are obliged to give support, the liability shall devolve upon them in the order provided herein. The spouse, okay, the descendants in the nearest degree, the ascendants in the nearest degree, and the brothers and sisters. Okay, so if, for example, uh, there is a person, let us say the husband or the wife is in need of support. If the wife is in need of support, the primary liability will fall upon the spouse. What if the spouse is not capable of giving support? Then the liability will go to the descendants in the nearest degree, meaning the children. Okay, what if none of the children have money and are not capable of giving support? Then the ascendants in the nearest degree, the parents. Okay, what if the parents are not capable also? Then the brothers and sisters of the person who needs support. Okay. How about if there are two or more persons who are capable of giving support? Okay, who shall be obliged to give support? When the obligation to give support falls upon two or more persons, the payment of the same shall be divided between them in proportion to the resources of each. So, for example, if there are two or more siblings who are capable of giving support. Now, the support shall be divided in proportion to their resources. Okay. In case of urgent need, the judge may order only one of them to furnish the support provisionally without prejudice to his right to claim support from the other obligors of the share due to them. Okay. How about if there are two or more recipients? Okay. At the same time, claim support from one and the same person, legally obliged to give it. Okay. And the person obliged to give it does not have sufficient means. Now, the order established in the preceding article relative to the person obliged to give support shall also be followed or applied. Okay. Unless the concurrent obligee should be the spouse and a child subject to parental authority, in which case the child shall be preferred. Okay. Now, the important thing to remember about support, okay, are, of course, what consists of support, the persons who are obliged to give support, and the fact that support, the judgment for support never becomes final. Why? Because it depends upon the means of the giver and the needs of the receiver. Now, the needs of the receiver might change because it might change because there might be the need for next year because he will go to college, okay, might not be the same as the need for this year when he is only a high school student. So it will depend upon the needs of the recipient as well as the means or the financial capacity of the giver. Okay. The amount of support shall be in proportion to the resources or means of the giver and the necessities of the recipient. Okay. Support shall be reduced or increased proportionately according to the reduction or increase of the necessities of the recipient and the resources or means of the person obliged to furnish the same. That is why the judgment for support never becomes final. Okay. Now, when does support become demandable? Okay, the obligation to give support shall be demandable from the time that the person who has the right to receive the same needs it for maintenance. But it shall not be paid except from the date of judicial or extrajudicial demand. So there has to be a demand, whether judicial or extrajudicial. But the right to support will arise from the time that the person who is entitled to receive the same needs it for maintenance. Okay? Okay. Now, what are the means of providing support? Is it needed that money be given, or will it be sufficient if the needs be provided in kind? Okay, Article 204 provides that the person obliged to give support shall have the option to fulfill the obligation either by paying a fixed allowance or by receiving and maintaining in the family dwelling the person who has a right to receive support. Okay, however, the latter alternative cannot be availed of in case there is a moral or legal obstacle there. So example, the obligation of support between the spouses. So if the husband, for example, chooses to provide support by maintaining the wife in the family dwelling, okay, if there is a legal obstacle to it, like for example, if there is a complaint against the husband for physical abuse, okay, then the option of maintaining the wife in the family dwelling is no longer feasible. So that option, the only remaining option for the husband is the payment of a fixed allowance. Okay. Another thing to remember about support, aside from the fact that judgment for support does not become final, is that the right to support shall not be levied upon on attachment or execution. So it is exempt from attachment or execution. Why? Because the person needs it for survival. So if you levy on attachment or execution on support, then you're depriving that person of his right to survive, his right to life, his right to survive because he needs it for his daily maintenance. That is the reason why support is exempt from attachment or execution. Can support be advanced by another person? If it is advanced by another person, can that person claim for reimbursement? Okay, Article 206 provides that when without the knowledge of the person obliged to give support, it is given by a stranger, the latter shall have a right to claim the same from the former unless it appears he gave it without any intention of being reimbursed. In the same manner, Article 207 provides that when the person obliged to give support unjustly refuses or fails to give support when urgently needed, any third person may furnish support to the needy individual with the right of reimbursement from the person obliged to give support. So there is a quasi-contractual relationship that is automatically created between the person who advanced the support and the person obliged to give support. Okay, unless of course the person who advanced the support, okay, did not have any intention or waived his right to be reimbursed. Okay, we now go to the cases. We have the case of Abelia versus Abelia. So, as you all know in the previous lectures, especially on filiation, support is one of the consequences or result of the establishment of filiation. Once filiation is established, support follows as a matter of right. Okay. In Abelia, the Supreme Court said that filiation must be established for a child to claim support from a putative father. Okay, an action for support may be directly filed where the matter of filiation shall be integrated and resolved. So there is no need to file a uh, uh, a case for establishment of filiation first before you can claim support. You can directly file a claim for support or a case for support and establish the filiation in the case for support. So, in this case, the issue is whether the CA erred in ruling that filiation proceedings should have first been separately instituted to ascertain the minor child's paternity. Okay. The Supreme Court categorically stated that an integrated determination of filiation is entirely appropriate to the action for support. An action for support may very well resolve the issue of paternity if it involves the same parties, is brought before a court of proper jurisdiction, prays to impel recognition of paternal relations, and invokes judicial intervention to do so. So that is settled that the filiation may be established in a case for support. You need not file a separate case for the establishment of filiation. Okay, again, this is another case which was previously discussed in the previous lectures, the case of Lim Lua versus Lua. So here, the issue is whether or not the advances made by the father to his children may be deducted in the amount of support which was granted by the court. Okay. The CA should not have allowed all the expenses incurred by the respondent to be credited against the accrued support pendente lite. The monthly support pendente lite granted by the court was intended primarily for food, household expenses such as salaries of drivers and house helpers, and also petitioner's scoliosis therapy sessions. The amount of support may be reduced or increased proportionately according to the reduction or increase of the necessities of the recipient and the resources or means of the person obliged to give support. Judgment for support does not become final. The right to support is of such nature that its allowance is essentially provisional, for during the entire period that a needy party is entitled to support, his alimony may be modified or altered in accordance with the increased or decreased needs and with the means of the giver. It cannot be regarded as subject to final determination. Okay, so that is the important thing to be remembered in the Lim Lua versus Lua case. Judgment for support never becomes final. Why? Because it will depend upon the necessities of the recipient and the means of the giver. And also considering inflation, okay, the amount, for example, that is awarded by the court, let us say if a 10,000 peso per month allowance, okay, after 10 years, that would no longer be sufficient. Okay, so there is a need to modify the support that is granted. That is why a judgment for support never becomes final. Okay, we have the case of Gotardo versus Puling. Okay, in this case, Divina filed the complaint for compulsory recognition and support pendente lite, claiming that the petitioner is the father of her child. Petitioner denied having sired the child. Okay, so the Supreme Court um, reiterated in this case that filiation proceedings are filed not just to adjudicate paternity but also to secure legal rights associated with it, such as citizenship, support, or inheritance. In paternity cases, the burden of proof is on the person who alleges that the putative father is the biological father of the child. So in this case, the respondent established a prima facie case that the petitioner is the putative father of Glipse through testimony that she had been sexually involved only with one man, the petitioner, at the time of her conception. However, the petitioner did not deny that he had sexual encounters with the respondent, only that it occurred on a much later date than the respondent asserted, such that it was physically impossible for the respondent to have been 3 months pregnant already when he was informed of the pregnancy. However, the petitioner failed to substantiate his allegations of infidelity and insinuations of promiscuity. Since filiation is beyond question, support follows as a matter of obligation. A parent is obliged to support his child, whether legitimate or illegitimate. The amount of support is variable, and for this reason, no final judgment on the amount of support is made, as the amount shall be in proportion to the resources or means of the giver and the necessities of the judgment for support never becomes final, which is first enunciated in the case of Lim Lua versus Lua. Okay? The next case is Nepomuceno versus Lopez. Okay, so in this case, Archbencel claimed to have been begotten out of an extramarital affair of petitioner with Araceli. However, the petitioner refused to affix his signature on the certificate of birth of Arbencel. However, he had executed a handwritten note, a notarial agreement to support a child whose filiation is admitted by the putative father was considered acceptable evidence. Letters to the mother vowing to be a good father to the child and pictures of the putative father cuddling the child on various occasions together with the certificate of birth proof filiation. However, a student permanent record, written consent to father's operation, marriage contract where the putative father gave consent cannot be taken as authentic writing. Standing alone, neither a certificate of baptism then says uh, the filiation cannot be established. In this case, there was a notarial agreement to provide support. So it is a public document, but there was no acknowledgement of paternity. Okay? Notarial agreement must be accompanied by the putative father's admission of filiation to be an acceptable evidence of filiation. Here, not only has the petitioner not admitted filiation, but he has consistently denied it. In order to constitute a competent proof of filiation that will entitle the child to support, the notarial agreement must be accompanied by the putative father's admission of filiation. However, not only has petitioner not admitted filiation, but he has consistently denied it. So the mere execution of a notarized document agreeing to provide support without accompanying admission of filiation is not sufficient to establish filiation. A copy of the certificate of live birth has also no probative value because the putative father has not signed the same. All that the child has is the petitioner's handwritten undertaking to provide financial support, which did not establish his filiation. Okay, we now move to the case of Patricio versus Dario. So in this case, Marcelino cannot demand support from his paternal grandparents because he has parents who are capable of supporting him. So the lesson to be learned in the case of Patricio versus Dario is the order of preference in the persons who are obliged to give support. So if you have parents who are capable of giving support, you cannot bypass the parents and go directly to your ascendants because the order of preference with respect to the persons who are obliged to give support must be observed. So the liability for support falls primarily on Marcelino's parents, especially his father. So the law first imposes the obligation of legal support upon the shoulders of the parents, especially the father, and only in their default is the obligation imposed on the grandparents. In the case of Patricio, uh, the characteristics of legal support were discussed. Legal support has the following characteristics. It is personal because it is based on family ties which bind the obligor and the obligee. It is intransmissible. It cannot be renounced. It cannot be compromised. It is free from attachment or execution. It is reciprocal and it is variable in amount. So the reason behind is that the closer the relationship of the relatives, the stronger the tie that binds them. Support is imposed first upon the shoulders of the closest relatives and only in their default is the obligation moved to the next nearer relatives and so on. Okay, we now move to the case of Lacson versus Lacson. Okay, so in this case, the sisters Maui and Mawana are the legitimate children of Edward. The petitioner left the conjugal home, forcing the mother and the children to seek apparently for financial reason shelter somewhere else. So the father, Edward, abandoned his family. So they went to seek financial support from the uncle. Respondents filed a complaint for support against the petitioner. Petitioner admits to provide support. However, he should not be made to pay support in arrears. Okay, to petitioner, his obligation is to pay only the support which was adjudged in civil case in the case for annulment of marriage, since only from that moment can it be said that an effective demand for support was made upon him. Petitioner's insistence on requiring a formal demand from his wife is truly pointless in the face of his acknowledgement of and commitment to comply with such obligation through a note in his own handwriting. Noel Daban, who owing to consideration of kinship had reasons to help, indeed lent his sister Leah money to support her children. So when the person obliged to support another unjustly refuses or fails to give support when urgently needed by the latter, any third person may furnish support to the needy individual with right of reimbursement from the person obliged to give support. So the resulting juridical relationship between the petitioner and Noel is a quasi-contract, an equitable principle enjoining one from unjustly enriching himself at the expense of another. So, if a person who is who needs support, okay, gets support provisionally from another person, a quasi-contract is therefore created between the person who advanced the support and the person who is obliged to give the same. Okay? Lam versus Chua. So in this case, Jose was ordered to pay monthly support to his son John in the amount of 20,000 pesos. He argued that there was already a provision for the support of the child, which was embodied in the decision for the annulment of marriage case, to which he agreed to contribute 250,000 for the benefit of the child. Now, another action for support was filed against the husband. So in this case, the husband was protesting because to his mind, he already gave support in the annulment case. Okay, so again, this is a reiteration of the basic principle in support that a judgment of support never becomes final. Judgment for support does not become final. The right to support is of such nature that its allowance is essentially provisional, for during the entire period that a needy party is entitled to support, its alimony may be modified or it cannot be regarded as subject to final determination. Thus, there is no merit to the claim that the compromise between him and his wife, which was approved by the court. So, in the case for voluntary dissolution of the conjugal partnership of gains, is a bar to any further award of support. To base its award for support on the evidence presented before it, the evidence must prove the capacity or resources of both parents who are jointly obliged to support their children and the monthly expenses incurred for the sustenance, dwelling, clothing, medical attendance, education, transportation of the child. So support never becomes final. Why? Because the means of the giver may change, the needs of the recipient may also change, and external factors such as inflation would also justify a modification of the previous award of support. Okay, so we have David versus Court of Appeals. Okay, in this case, the petitioner Daisy worked as a secretary of the businessman Ramon. Ramon is a married man. They had an illicit relationship of which a son and two daughters were born as a result of that relationship. Okay, for failure to return her minor son, Daisy filed a petition for habeas corpus. The same was granted, and temporary support in the amount of 3,000 pesos was ordered. Okay, so Christopher is an illegitimate child since at the time of his conception, his father Ramon was married to another woman. The fact that the private respondent has recognized the minor child is a ground for ordering him to give support, but not for giving him custody of the child. So under Article 204, a person obliged to give support can fulfill his obligation either by paying the allowance fixed by the court or by receiving and maintaining in the family dwelling the person who is entitled to support unless there is a legal or moral obstacle to do so. So indeed, if the private respondent loves his child, he should not condition the grant of support on the award of his custody to him. So there is a legal or moral obstacle to getting the child because the child should be in the custody of the mother since he is an illegitimate child and considering also the age of the child. Okay, so the person who is obliged to give support cannot choose the option of just taking the child with him and providing for support by keeping him in the family dwelling. So the only option that is available to the petitioner would be the giving of a fixed monthly allowance. Okay, the last case is the case of Versosa versus Versosa. So we have already discussed this when we are taking the parental authority chapter. Okay, in the case of Versosa, the support was partly discussed. Okay, because it enumerated the things that are covered by the provision for support. Okay, and the characteristics of a judgment for support. Support is anything which is indispensable for sustenance. Support cannot be renounced, transmitted to third persons, nor compensated with what the recipient owes to obligor. Compensation may not even be set up against a creditor who has a claim for support. Support in arrears is different altogether. It may be compensated, renounced, and transmitted by onerous or gratuitous title. Why? Because it is already in arrears, meaning it is no longer needed for survival. Okay, whereas present support is needed for survival. That is why it is exempt from levy or execution. Okay, the right to support is not susceptible of future transaction. Okay, since the present action also revolves on the right to future support, and because compromise on future support is not allowed, then the conclusion is irresistible that an attempt at compromise of future support and failure thereof is not a condition preceded to the filing of the present. Okay, so that is all for support. Thank you for listening, and don't forget to subscribe to this channel.